So in these religious liberty claims, it's not usually just one kind of social interest group. It's a very ideologically diverse coalition. In the other case, like you mentioned, Christian Legal Society, Knights of Columbus filed amicus briefs, so did the Sikh Coalition, the Episcopal Church, Presbyterian Church, Mennonites, Anabaptists, Unitarians, Quakers. If you spin the wheel of religions, one of them is probably going to have filed an amicus brief in support of Oak Flat at some point. And it just goes to show that religious freedom is good for society generally. In U.S. history and in the American moment today, the need for religious freedom is a diversely held priority.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Joseph Clement, Content and Program Manager at Napa Legal.
You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. So this week, we have an interesting group of cases and situations to cover. We're going to start with a recent executive order that came out earlier this month from President Trump to combat debanking of conservative and religious organizations. Then we'll go to California and talk about a recent case where religious organization was excluded from otherwise generally available use of school facilities. And then we'll finish with a quick update on the Apache Stronghold case, the battle for control of Oak Flats, the Native American sacred site that was originally a religious liberty case that Beckett was arguing and has now, we thought it was dead. Now it's not quite dead, but we'll get into that at the end. But first things first, let's start with this executive order. So this month, it was August 7th, I believe, President Trump signed the Guaranteeing Fair Banking for All Americans executive order. It took several steps to prevent publicly funded as well as private banks from refusing service to individuals and groups based on their either political or religious beliefs. We'll get into some of the details in a minute. But among other things, it instructs federal banking regulators to eliminate or amend any regulations that could result in politicized or unlawful debanking. I think that's a good summary of the purpose of the executive order. And there's also some look back provision requiring the Small Business Administration to inform all financial institutions that receive SBA funds that they have to reinstate any clients that were unlawfully debanked, denied service for discriminatory reasons. So I want to get into the beginning of the executive order. I think it's been really important. It's a good general way to lay out legal documents, but the executive orders from this administration have done, I think, a really good job of starting with strong preambles, strong section 1, laying out the foundation of this is what's going on. These are examples of it. This is why this is important before getting into the legal functioning sections of the executive orders. So in the beginning of the executive order, I'm going to read from it at length here because I think it's important to lay out what's going on here and why there's a justification for this executive order. So I'm going to read from it. Quote, some financial institutions participated in government-directed surveillance programs targeting persons participating in activities and causes commonly associated with conservatism and the political right, following the events that occurred at or near the United States Capitol on January 6, 2021. The federal government suggested, and this is real, the federal government suggested that such institutions flag individuals who made transactions related to companies like Cabela's and Bass Pro Shop, which sell guns, by the way, or who made peer-to-peer payments that involve terms like Trump or MAGA, even though there was no specific evidence tying those individuals to criminal conduct. So this is mostly laying out the foundations of political discrimination in some banking practices. The executive order goes into a particular example called Operation Choke Point, which the executive order says was a well-documented and systemic means by which federal regulators pushed banks to minimize their involvement with individuals and companies engaged in lawful activities and industries disfavored by regulators based on factors other than individualized, objective, risk-based standards. That last sentence is the reason that I read this quote, right? They give you the intro. This is what's going on. There are clear examples of discriminatory banking practices, and then the problem and the repurposing that the administration wants to see in banking is in that last sentence, right? They want to keep the banking industry from doing anything but basing the factors by which they do their banking practices. It should all be based on individualized, objective, risk-based standards, right? So the idea is that banks as part of the market should have they obviously have to have principles by which they approve or deny services, right? But they should be, again, individualized, objective, risk-based standards, right? Is this loan risky? Is this person willing to pay it back? Is this organization engaged in things that are going to risk their funds and therefore their relationship with this bank, and so on? Now, I'm not a banker, but just on policy level, this makes sense, right? And then what this executive order has pointed out is that that is not, in fact, what's happening. There are other criteria that are viewpoint based on political or religious principles that are being considered or have been considered by banks in their banking practices. And that's a problem. So the executive order goes on to say that the principle is that these practices, these kind of viewpoint-based discriminatory practices, are incompatible with a free society, and the principle that the provision of banking services should be based on material, measurable, and justifiable risks, right? That's what banks should be evaluating, not how conservative or how religious a potential client is. So we go from the purposes and the examples to the actual requirements for regulators. There are several, but I think one that I want to focus on here is in Section 4 of the executive order. The order requires that each appropriate federal banking regulator shall, to the greatest extent permitted by law, remove the use of reputation risk or equivalent concepts that could result in politicized or unlawful banking, debanking, as well as any other considerations that could be used to engage in such debanking from their guidance documents, manuals, and other materials. So what's going on here? The purpose of this is to make sure that banks are only considering who they will and will not do business with based on neutral banking principles, right? And the issue is that there's been this trend of, I want to see if I can find the exact term, but basically where banks have instituted practices where if an organization or an individual's reputation, right, is such that it could lead to risk, right? If it's an organization that's working on a hot button social issue, it's like, well, what if they get closed down? What if they get raided? What if they get arrested? What if it's hate speech? Like, what do we do with them? Is that part of our risk-based, neutral assessment of whether this is a good banking client? Now, the executive order actually acknowledges that, but they go on to say, well, regulators have to ensure that any consideration of reputation is considered for, if it's considered for regulatory, supervising, banking, or enforcement purposes, it should be done solely to the extent necessary to reach a reasonable and apolitical risk-based assessment. Now, this is a hard needle to thread here, right? Because in theory, that's right? There can be organizations or individuals who are doing very politicized, very controversial things that could, in fact, jeopardize their business or their ability to pay back a loan, for example. The problem is, there's been some good commentary on this, but there's a huge problem because these just are not being applied even-handedly, right? So these kind of principles have been used, and there are a lot of documented examples to focus on organizations that are involved in certain types of religious and conservative activism, particularly on the same-sex marriage issue. And that's what's at issue here. And so I just want to note before I wrap up on this topic that this is not a hypothetical concern for religious organizations. I know the executive order focused on like January 6th and gun ownership and like conservative political positions, but there are real examples of religious organizations being debanked. Prominent among them, the National Committee for Religious Freedom, which is former Ambassador Sam Brownback's organization, was debanked with no clear explanation in 2022. JPMorgan Chase closed down their account. The Family Council had a similar problem also with JPMorgan Chase in 2021 when suddenly its credit card processor account was closed down. So it's a real problem. And I will note that even before this executive order, this practice, I think, peaked about 4 or 5 years ago, and it's been pushed back on. So I would just say many banks over the last like 2 or 3 years have kind of shifted gears on this. This viewpoint rule was popular, like I said, around 2020, 2021, 22, where conservative or religious messages could be considered hate speech. This was in the codes of conduct of some of these big banks. And if the organizations or the individuals were engaged in what was considered hate speech, even if that was in fact just like a religious message on the truth about marriage, then that could warrant bank administrators to cancel religious groups from their platforms for their views. So most banks have abandoned these rules over the last year or so. I think JPMorgan Chase publicly backed off and changed their rule about a year ago. But the last holdout of the major banks was Bank of America, and they just also shifted gears in the last couple of months. This is all speculation. There's some thought that they knew this executive order was coming and that the federal regulators were no longer going to tolerate these kind of discriminatory practices. But Bank of America, I believe it was in June, they went public and clarified that their code of conduct now made clear that religious views are not a factor in any account closing decision. So to wrap up here, I would just say two things. One, these institutional trends are really important. Um, they're not sufficient, but they're an important start, right? Like there needs to be more banking legislation and regulation at the state level, at the federal legislative level, to prevent these things from continuing to happen. The executive order isn't just a silver bullet that stops these kind of debanking threats. But the executive order is helpful to, first of all, put pressure on banks through regulators, but also just to make the issue more public, right? It's important to note that a prominent national politician's power is not just his legal authority, but the bully pulpit, right? So just putting the world on notice that here are some examples. There are actually banks engaging in discriminatory debanking practices. This is a problem. We want to do something about it. Just shining a little light on this is rather important. And the other thing I would say is that these kind of institutional solutions they're good because they put banks on notice that you can't just get away with doing these things. But it is a tricky thing because I think it's not usually done in the light of day, where a bank will just say, okay, well, you violate our policies, right-wing conservative organization, whatever it is. And so we're publicly taking away your right to bank with us because you violate our policies. Often these things are done in like roundabout ways where all of a sudden, like we had said with the National Committee for Religious Freedom, there wasn't really an explanation. All of a sudden the bank account was frozen and nobody could really figure out what was going on. And then sometimes these things happen, but then the account is unfrozen and a week later or 2 weeks later, so, oh, sorry, that was a technical error or a mistake, but in the process your payroll was frozen, you couldn't get your bank account. So systemically, it's good to see these kind of things happening. Regulation needs to fix it and put pressure to make sure that there are not discriminatory banking practices going on, but it's really hard to police on the margins. Similar to we've talked about at Napa Legal, social media deplatforming, same thing. It's like, well, if somebody explicitly says, well, you're off this platform because you're too Catholic or you're saying XYZ about same-sex marriage, that would be more obvious, but often people's accounts just kind of freeze and disappear for unknown reasons, and then they come back eventually after some harm is done. So this is a good start. I hope it will put the focus on it, and we'll continue to see more regulatory and legislative creative solutions to continue to address this and ensure that our religious organizations are not being debanked or treated unfairly by financial institutions.
Yeah, I want to add a few comments to kind of tie this particular order into the bigger picture that I've seen in the last few months in the religious liberty movement, specifically how sources of funding, both where funds do and don't come from, has been at the heart of a lot of legal and policy changes in the past couple months and year plus. Um, and I've seen kind of two big takeaways and really advancements that I've seen. For one, it's that people and the government are freed not to give funds to organizations and causes that they find morally and religiously objectionable. Right. The big thing we saw this year was with the Scrimeti decision. Tennessee said we're not going to give funding to abortion providers anymore because we're not spending taxpayer dollars on this thing that most of them find very objectionable. And that was upheld. And similarly, Oklahoma's governor Stitt signed an executive order saying a pretty similar thing. There's a lot going on right now at the federal level with Planned Parenthood, whether they'll receive funding or not from the public. And on the flip side of that is that faith-based institutions have the same right as secular ones to receive public and private funding. We discussed recently the Small Business Administration said on the public side, churches and other faith-based institutions can start receiving their emergency disaster loans, which was a change in policy. On the private side of things, donor privacy has been a big thing. We've seen some states enacting more laws protecting the privacy of donors who give to organizations. And this and other similar action on the both public and private sectors, where banks aren't revoking funding because somebody's religious. So there's certainly more work to be done with the funding side of things in the religious liberty movement, but this isn't an isolated incident. It's certainly something that's been seen a lot of gains in the last year plus.
Just for our close listeners, just want to make sure that we clarify the record, because you had mentioned Scrimetti. So Scrimetti bans the transition.
Oh, sorry, Medina. Yeah,
Medina. Medina is the abortion condition. No, it's okay. It's just I know people listen carefully, and I love feedback, but I don't want that to be the feedback.
Yeah, no, thank you. Thank you.
But that's a great comment. Thank you for wrapping up that topic.
Yeah, so we'll move into our second update, where we'll talk about what happened when a California public school district opened its doors to everybody but a Christian nonprofit. So for the background, the Oakland Unified School District, which is a public school district in California, lets groups use public school facilities after school hours have finished. This is kind of a common practice where the school day will finish, and then the public school will say whatever groups can come in and use our space. There's a somewhat complicated system to apply to use the spaces. There's like different tiers and classifications of organizations. But basically, it just means there's lots of different ways for organizations to apply to use public school facilities after the school day has ended. And it's open to a wide swath of organizations, both secular and religious. So this one particular Christian group, the Christian Evangelism Fellowship, CEF, you might hear them referred to further on this podcast, applied for this one particular program of theirs called the Good News Club. It's basically a Christian religious education and activities. It's free for any kid to attend, whether they're in school or not. And it would take place in the school, like gym or something like that, after the school day is over. They applied in all the different ways, and they were always denied. And it was pretty clear that it was because of their religious identity. In the lawsuit that we're going to talk about, the school district claimed that they denied the CEF's applications because the space was being used. They pretty quickly backed off that claim when it was clearly not true. And the CEF gave the court lots of emails and specific conversations where school officials said, "We're denying you because of your religious identity." To quote from the brief, and this is actual quotations from principals and different public school administrators. One said, "As a public school, we are not in support of evangelism on our campus." Another said, "CEF would likely be denied access because it was religious." And kind of a more curt and tongue-in-cheek statement, "We cannot have any Bible clubs at school. Sorry." So all of these very clear examples of CEF was denied use of this public school facility, while other comparable secular and other religious ones were granted access. So in this lawsuit, which is in a federal district court in California, CEF was seeking and was granted a preliminary injunction. So the case will still proceed, but this is a good indicator that the court is probably going to rule in favor of CEF, and it was on a free speech claim. So in order to get this preliminary injunction, CEF basically had to show that they would probably win this case on the merits of their free speech claim, which they very successfully did. Basically, the court ruled that the district school facilities are a limited public forum, and this was completely undisputed. The school district didn't agree. A limited public forum, for anyone unfamiliar, is basically an otherwise non-public space that the government has made public for particular discussions. So public schools do this often, where they'll say, "Oh, usually people aren't allowed in the public school throughout the day, but we're going to have a hearing on the budget or whatever, so anyone can come in and we're going to talk about the budget this afternoon." Now, because of this limited public forum designation, there are some regulations that the government has to follow. They don't have to allow any type of speech. They can still restrict some things. But citing pretty established case law, the court noted that they cannot regulate speech based on viewpoint or on the content of the beliefs in a limited public forum. So in this case, the school district opens its facilities pretty broadly. Like the Boy Scouts would use it. This Jewish community center would use the school facilities after hours. Lots of different organizations, basically for everybody but the Christians. And since the government opened up the school facilities and made them a limited public forum through this program, they cannot restrict the speech based on the content of what's expressed. And the CEF gave clear evidence that they were restricted access because of the content of their religious beliefs. It's worth noting the school's argument, which has time and time again failed at various levels in the courts, After they discarded the claim that they didn't have space, which they clearly did, they said that it would be an establishment clause violation for them to permit CEF to come into the school facilities. And they basically said that they would be discriminating against other students by elevating one faith above the others, which was clearly false on very a numerous amount of counts. For one, this is after school hours, so no students would be there that wouldn't want to be. So there's no discrimination because the only students that are at this program are there because they want to be there. There's no sponsorship from the school. The program is open to anyone. And the court noted the Trinity Lutheran and the Carson v. Makin line of cases where basically a government agency or official cannot deny a generally available public benefit solely on account of the person's religious identity. So the upshot of this, again, we've seen this time and time again, where this argument that the Establishment Clause is violated when a government official is fair and even-handed to a religious organization, that is not a violation. In fact, the opposite would be a violation of the Establishment Clause. We saw this in this year's Catholic Charities case, which basically said that if you're being unfair and treating a religious organization worse than comparable secular ones only because of their religious identity, that is not what the First Amendment is meant to do, and it's actually the opposite. So Frank, I'll hand it off to you to add your commentary.
Yeah, I think you pretty much covered it. I would just make a couple of brief remarks. I think you're right on. I mean, this is yet another case that is a state actor doing exactly what our line of cases leading up to Carson v. Makin says you cannot do. Generally available, all comers, but not religious ones. You can't do that. And the reasoning that came about that has been repeatedly rejected, especially in Carson, is like, well, even if this isn't strictly establishing a religion, we're I'm paraphrasing, but the argument goes something like, we're just trying to go above and beyond to make sure we're not doing anything like establishing religion, which the court has repudiated pretty strongly, and which I will just never tire of saying that's not what an establishment of religion is, right? Having this like non-denominational Christian Good News Club after school in a school facility is not establishing a religion unless and until you do something like say no Jews, right? Or like the Methodists can come do their thing, but the Catholics can't do their thing. Then you have an establishment clause problem. I don't get tired of saying this because I think it needs to be continuously injected into the public conversation. Like that's what establishment means. Like to establish a religion had a very specific legal meaning. That's why it was written that way. The First Amendment didn't say government shall use no money to do anything religious, because that would mean something quite different. And the government did use money to do religious things all the time. So that's not what an establishment of religion is. And I'll say the particular irony, I think one of these the quotes from the conversations in this court case, right? We cannot have any Bible clubs at school. Sorry. If it's we don't want to, because we think it looks too much like establishment, that's a problem because what we just said, Carson and its line. But if you're thinking we cannot have any Bible clubs at school, again, that's wrong for the Establishment Clause reasons I just mentioned. But also I think it's pretty rich because the very foundations of the public school system in America in the like mid 1800s was, and I've probably talked about this before in discussion of the Oklahoma St. Isidore case over this past year, but the wave of Catholic immigration brought with it a lot of Catholic parish schools. They were very influential. They started to catechize and educate children in large numbers in the Catholic faith. And so Protestant dominated states responded by starting public schools, publicly funded schools that were not denominational, but very obviously Christian. I mean, this is not debatable, right? Like these early public schools taught the King James Bible. They prayed the Our Father in the school. So they were not sectarian. They were not of a particular denomination that was like the state church. But to say we cannot have any Bible clubs at school, sorry, like the first public schools essentially had Bible clubs as part of their class time. So here we're just talking about the use of school facilities outside of school time, which is even less of a problem. But to say that like religion can't have a place in public school, public education is just historically inaccurate. So I will get down off of my soapbox on that issue, and we will wrap up with this is just kind of a quick note because this is way outside of our area of legal interest and expertise, but it is relevant to people who follow religious liberty cases. So if you've listened to this podcast or followed our weekly email, or if you just are involved in religious liberty legal or policy work at all, I'm sure you've heard of the now years-long battle over Oak Flat, which is often known as the Apache Stronghold case. So if you were following this, the saga from the religious freedom standpoint ended this past May when the Supreme Court declined to hear this lawsuit. It was over the transfer of Oak Flat, which was a Native American worship site in Arizona. Um, the details of it, if you recall, were it was a complicated case, but there ended up being a legal transfer of rights to this site from the religious Native American groups that were using it to a mining company that was basically going to mine the underlying area, which would make Oak Flat itself kind of a crater. So the problem was it would have jeopardized and ended the very existence of Oak Flat, which was a sacred site to this Native American tribe. So the lawsuit was going on for a long time. The lawyers at Beckett were representing Apache Stronghold. There were amicus briefs from a lot of friendly organizations, Christian Legal Society, the Knights of Columbus. And the central claim there was that the transfer and obviously the subsequent destruction that would come with the transfer from Apache Stronghold to the mining company would violate the Federal Religious Freedom Restoration Act. The circuit court in that case did not accept that argument, and then cert was denied, which would eventually end the saga because then the transfer of land goes through, and once the mining company has it, they destroy it, and there's no more argument to have. So we thought this was over as of May. Interestingly enough, it seems that while the religious freedom claims are pretty much dead, the fate of Oak Flat is not yet decided, apparently. So Joseph just came across this case earlier last week that there was a parallel lawsuit that had been going on involving Oak Flat that was recently advanced in the Ninth Circuit, where several plaintiffs claim that the U.S. Forest Service's impact report fails to meet several procedural requirements, violates a number of environmental laws, and so the transfer and destruction of Oak Flat would actually violate a bunch of regulatory and environmental laws. That seems to be succeeding. The court recently granted a temporary injunction. It paused the land transfer to the mining company until the court would decide the case on the merits. So again, while the RFRA claim fails to reach the Supreme Court, efforts to protect Oak Flat itself are proceeding. So the case will continue. I think we'll get some update on that this fall. Again, I'm not at all involved in environmental law, so I cannot really comment on the legal claims. But I think it's interesting for our listeners to note that if you look at who the parties are filing the lawsuit, it's clear that it's coming from a different angle than lovers of religious freedom. The plaintiffs on the case are the Arizona Mining Reform Coalition, the Intertribal Association of Arizona, Earthworks, the Center for Biological Diversity, Access Fund, and the Grand Canyon chapter of the Sierra Club. So a number of Native American groups and environmental groups in particular. So I think while the fate of Oak Flat now doesn't really have anything to do with religious liberty from a legal perspective, I think there's an interesting commentary here on the potential and the importance of creative and multifaceted legal strategies when we're dealing with religious liberty issues, right? If you're a religious liberty group trying to protect religious exercise, when the government comes in and tries to give a sacred site to a mining company, I think it's creative to think about, well, what else can we do? We should certainly file RFRA claims and First Amendment claims, but if you can incorporate in that case environmental land use claims when trying to protect that religious land, can be a smart legal strategy. And it reminds me of like what Alliance Defending Freedom has been doing in a lot of these kind of religious slash speech slash expressive association claims. Like I think of 303 Creative, which was decided as this free speech issue, Childs versus Salazar, which is primarily a free speech issue that's going to come before the Supreme Court in this coming term. I think it's a smart approach to make sure that we're clear about the religious exercise claims and the religious rights we're trying to protect, but to focus on every legal claim available to protect the religious rights of individuals and organizations, whether that be, throwing in free speech and free association claims along with free exercise, whether that be throwing in environmental claims along with RFRA claims to protect a sacred site. I think it's just a good reminder of how lawyers in this kind of public interest and religious liberty sphere should never close off an avenue if there's a way to protect religion through the courts. So, Joseph, any thoughts on this case before we wrap up?
Yeah, absolutely. Like you were saying, using these kind of different claims. I think ADF has been doing with a couple other parental rights cases we've talked about. Due process is a lot of times invoked as well. We talked about the Vitsaki case where basically this public school socially transitioned. I forget if it was a boy or a girl, but against the parents' wishes and deceived the parents about it. And they're also raising a due process in addition to the free exercise claim. So that's a trend that we'll kind of keep tracking the success of. Um, and whenever we have these cases that show how many different groups are involved with it, it's helpful to note the ideologically diverse parties in this lawsuit and really in the other one that failed to reach the Supreme Court. So in these religious liberty claims, it's not usually just one kind of social interest group. It's a very ideologically diverse coalition. In the other case, like you mentioned, Christian Legal Society, Knights of Columbus filed amicus briefs. So did like the Sikh coalition. The Episcopal Church, Presbyterian Church, Mennonites, Anabaptists, Unitarians, Quakers. If you spin the wheel of religions, one of them is probably going to have filed an amicus brief in support of Oak Flat at some point. Um, and it just goes to show that religious freedom is good for society generally. In US history and in the American moment today, the need for religious freedom is a diversely held priority. It's not like a Christian nationalist kind of radicalized view. It's very much an American view. Look, in this case and in other policies, there just is a very widely backed priority. In the Mahmoud v. Taylor case, it was Christians and Muslims. The 1993 RFRA was sponsored by Chuck Schumer, passed nearly unanimously in the House and Senate, and then was signed into law by Bill Clinton. Even the American founding was led by members of very diverse faith backgrounds, Christian, deist, and otherwise. So even this isn't a religious claim, it's just a great opportunity to highlight how these cases have such broad support, and they tell us a little bit more about why religious freedom matters and who's behind it.
Yeah, no, that's a great way to wrap up. So while this has now left the domain of religious liberty law, we will still keep our listeners updated on what the fate of Oak Flat ends up being through this Ninth Circuit case on environmental law. All right, and that wraps it up for this week. So thank you all for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it if you like and subscribe from wherever you're listening, YouTube, Spotify, or elsewhere. And that if you enjoy and appreciate the work we're doing, we always encourage you to donate and support that work financially insofar as you are able. You can go to the Napa Legal website and do so if you would like. So we hope you'll join us next week as we continue to highlight, discuss some of the most important ongoing legal issues that affect religious liberty and the work of faith-based nonprofit organizations. Thanks for being with us. We'll talk to you next week. God bless you.